Okay, the Rules Committee will come to order. Shell companies today often operate in the shadows. They take advantage of loopholes in current law to make illicit profits and conduct illegal activities, all while hiding their true donors. Bad actors have used this reality to go on a global crime spree, funding terrorists and even going so far as to circumvent U.S. sanctions on countries like North Korea and Russia. The bill we're considering today, H.R. 2513, will close these loopholes and give law enforcement the tools they need to crack down on this crime. It's time to bring America's standards in line with other nations. This is a bipartisan bill that will finally shine some sunlight on these shell companies. With that, I'm happy to turn to our ranking member, Mr. Cole, for any remarks that he wishes to make.
Thank you, Mr. Chairman. Today's hearing covers one bill arising from the Committee on Financial Services, H.R. 2513, Corporate Transparency Act of 2019. I note that the manager's amendment that has been filed would also incorporate the text of H.R. 2514, the Counter Act of 2019, a bipartisan bill that was expected to come to the floor this week on suspension of the rules. In general, H.R. 2513 will require corporations and LLCs to disclose their beneficial ownership, or in plain English, disclose who actually owns those corporations and LLCs. Making those disclosures and preventing wrongdoers from hiding behind...
Suspend 1 second.
Sorry.
You just want to order here? Okay.
Making those disclosures and preventing wrongdoers from hiding behind anonymous ownership of these entities will go a long way toward combating money laundering and tax evasion. While I'm pleased the Committee on Financial Services was able to produce a bill that garnered significant Republican support, H.R. 2513 is not a perfect bill. I think members on both sides of the aisle have proposed some interesting and thoughtful amendments that would make this bill better, and I would urge the committee to make as many amendments in order as possible to ensure that members have a voice. As always, Mr. Chairman, I look forward to a thoughtful discussion on the legislation today. With that, I yield back.
Thank you very much. Ranking member yields back. I want to thank him for his opening. Now I'd like to welcome our witnesses to provide testimony on H.R. 2513, the Corporate Transparency Act. Subcommittee Chairwoman Maloney and Ranking Member McHenry, we are delighted that you are here. Anything that you brought in writing will, without objection, be entered into the record. And I now recognize the gentlewoman from New York, Ms. Maloney.
Thank you, Mr. Chairman, and Ranking Member Cole, and members of the committee for having us here today to testify on H.R. 2513, the Corporate Transparency Act. This bill will crack down on the illicit use of anonymous shell companies. This is one of the most pressing national security problems we face in our country, because anonymous shell companies are the vehicle of choice for money launderers, criminals, and terrorists. Unfortunately, we know that the U.S. is one of the easiest places in the world to set up anonymous shell companies. As any FBI agent or prosecutor will tell you, far too many of their investigations hit a dead end at an anonymous shell company. H.R. 2513 would fix this problem by requiring companies to disclose their true beneficial owners to the Financial Crimes Enforcement Network, or FinCEN, at the time the company is formed. This information would only be available to law enforcement and to financial institutions so they can comply with their Know Their Customer rules. This bill will plug a huge hole in our national security defenses and would be a massive benefit to law enforcement. And we have a very large coalition supporting the bill. We have the support of 127 NGOs, all of the law enforcement groups, all of the banking trade associations, the credit union trade associations, human rights groups, state secretaries of state, most of the real estate industry, and many, many more. We passed this bill out of committee with a strong bipartisan vote. Unfortunately, not with the support of Ranking Member McHenry. The ranking member did make a good faith effort to work with us on this bill, but he could not get the information he wanted from Treasury in order to support the bill, which was a source of frustration for both of us. But I did work with many other members on the other side of the aisle to make changes to the bill in the markup, and I am happy to continue working with my Republican friends to improve the bill. Related to corporate transparency is Chairwoman Waters' Manager's Amendment, which consists of modified version of H.R. 2514, which is Mr. Cleaver's Coordinating Oversight, Upgrading, and Innovating Technology and Examiner Reform Act of 2019, or the Counter Act. This amendment closes additional illicit finance loopholes and high-risk commercial real estate transactions and the transfer of arts and antiquities. It also examines Chinese money laundering, an issue seen in opioid and meth production, as well as many other types of trafficking, and creates a national strategy to fight trade-based money laundering. The amendment mandates a privacy and civil liberties officer and an innovation officer in each of the federal financial regulators and requires these leads to meet regularly to consult on Bank Secrecy Act policy and regulation. It imposes new penalties on financial institutions and personnel who commit egregious acts and creates a whistleblower program to encourage and protect those who identify bad actors. But the amendment also works to lower the compliance burden, establishing several tools to allow for more targeted sharing of related information. Finally, among other provisions, the amendment makes modest increases to the currency transaction reporting limit and studies ways to reduce the costly process of researching and writing suspicious activity reports. With support from law enforcement and financial institutions of all types and sizes, the bill passed our committee with a 55-0 vote. The chair and I want to thank Mr. Cleaver for his leadership on this issue. Chairwoman Waters has filed this amendment because the committee strongly believes that these two bills must be sent to the Senate together, combined into one. There is already a Senate bill, the Bipartisan Illicit Cash Act, which unites these two sets of issues. We understand that the chair and ranking member of the Senate Banking Committee are drafting their own version, merging the contents of our two bills. It is for this reason that the chair submitted the manager's amendment to add H.R. 2514 into H.R. 2513, to be voted on together and to be sent to the Senate as one bill. I ask that Chairwoman Waters' amendment be made in order and be part of H.R. 2513. I thank you for inviting us to testify, and I'd like to answer any questions you may have.
Thank you very much, and I'd like to recognize the gentleman from North Carolina, Mr. McHenry.
Well, thank you, Chairman McGovern, Ranking Member Cole. I'm here to testify in opposition to H.R. 2513, but I first want to begin my statement by commending Chairwoman Maloney and her approach to this. She did seek engagement from committee Republicans, and it was welcome, and I do appreciate her incorporating a number of ideas. There are a number of frustrations, as she mentioned in her statement, about getting data from this administration and the previous administration from FinCEN, the Financial Crimes Enforcement Network, which is housed in Treasury. In particular, data to justify the thresholds within this bill. Chairwoman Maloney and I both requested this information. We both requested a classified briefing and were rebuffed in those requests. And so my frustration is with those agencies of government, not with my colleague and her engagement on an important piece of legislation, but one that is difficult in nature. And we both agree that combating illicit finance is a nonpartisan issue that all members want to address. But our actions must be thoughtful and data-driven. I'm concerned this bill we're considering today is solely driven by anecdote rather than by hard data. For several months leading up to the committee's consideration of this bill, I sought data from FinCEN and Treasury, as I just outlined, along with the Department of Justice, to better understand the need for this legislation. I asked questions about, 1, the impact on small businesses, 2, why the thresholds that were set in this bill were set at those levels, and whether or not they were appropriate, and how the personal information of small business owners could be protected once gathered. We know that there are a number of data breaches within existing government databases, and we want to make sure that small business owners don't fall victim to what we as government employees have already fallen victim to, which is the breach of our personal data. Answers to these questions will allow us to craft a better bill that better understands the costs and benefits of this new requirement and could garner broad support. Unfortunately, we still have not received answers to any of these important questions. This has resulted in a less precise bill with potentially harmful consequences, particularly for small businesses. I'm concerned this bill will negatively impact many of these small businesses by driving up costs and hurting the bottom line. H.R. 2513 requires the smallest of these American businesses, with fewer than 20 employees and under $5 million in gross receipts to file annually a list of all beneficial owners of the business with the Financial Crimes Enforcement Network, or FinCEN. Few here in Washington have heard of FinCEN, much less the average small business owner in America, yet they're going to have a new request for data they're going to have to comply with. Supporters of the bill will argue that small businesses are already required to file as a result of FinCEN's customer due diligence rule. I will remind them that this bill does not rescind that current regulation, meaning small businesses will be required to file both with the financial institutions they currently have to file with this information, along with FinCEN, unless directed otherwise, or further rulemaking from the administration. We're on the verge of creating an entirely new federal government database. I think members need to be aware of that. We're placing the burden to comply with this new database entirely on small businesses and small business investors. We're doing it without any direct evidence to justify this mandate. Not just anecdote, but hard data is missing. This issue merits an extraordinarily thoughtful solution that doesn't treat legitimate small businesses as collateral damage. Thank you for the opportunity to testify. I welcome your questions.
Thank you very much. I appreciate the testimony of both of you, and I have no questions. Mr. Hastings?
I appreciate the witnesses. I have no questions.
Mr. Cole?
Just quickly, I also have no questions. I will just notify folks I'll be offering an amendment later for an open rule on this. But there's a lot of good things here, a lot we've worked together on, and I hope we can continue the process through and arrive at a bill that, frankly, in a bipartisan sense, we can all be pleased with. But I commend the efforts that have been made to date.
Thank you, Ms. Torres.
Thank you, Chairman, and thank you, Congresswoman Maloney and Ranking Member, for bringing this bill before us. Anonymous shell companies and other corporations are not required by law to report their true beneficial owners. These anonymous shell companies become vehicles for the drug cartels, money launderers, and terrorists to hide their illegal dealings. There are two cases. One case that I have been working on. In 2017, the NGO of Global Witnesses released a report documenting money laundering at Panamanian Club. The report even indicated that the Colombian money launderers may have used the hotel to launder drug money. Chairman Engel and I have been investigating this matter and demanded answers from the organization and the Drug Enforcement Agency with no luck. The organization is a Trump Ocean Club in Panama. And this is why we need stronger laws like the Corporate Transparency Act to keep this from happening in the first place. By operating in secret without any disclosure requirements, we are inviting the criminal behavior into our communities. In September, this is a case in my district. In September, the trial for a $123 million workers' comp scam began in the Inland Empire. The scammers used a medical group to run sham clinics. They prescribe highly priced medications regardless of the patient's condition and then bill the California workers' compensation system. In some cases, the medication was never even given to the patient. The alleged criminals were using anonymous shell companies to launder their illegal exploits. This case makes me wonder how many other illicit dealings are occurring without our knowledge because law enforcement does not have the proper tools to intercept these criminals. This is a common sense solution to help our law enforcement officers do their jobs. The California workers' comp system, is in trouble, and California legislators have been trying to update it to ensure that is there for the injured workers. And for these shell companies to take money out of that and then transfer it to European, Middle Eastern, and other companies is something that we absolutely need to stop. I want to enter into the record an article that cites that incident in the Inland Empire, the area that I represent, from My News LA.
Without objection.
Thank you, and I yield back.
Mr. Waddell? Mr. Perlmutter?
Just a statement. I want to thank the chairwoman for bringing this bill, Mr. McHenry, for you and the Republican side of the aisle working with her on it. This is something that's been pending for a long time, both the bank secrecy component, but particularly the beneficial ownership piece of this thing. And it's difficult. There's elements of privacy and disclosure, but at the end of the day, there is a national security component and a law enforcement component that we have to address. And, you know, making sure that we know who owns these properties from the outset. There has been a difference of opinion. Is it the responsibility of the lawyers at the beginning of the corporation or the LLC to make the disclosure? Is it the responsibility of the Secretary of State, the financial institutions, FinCEN, the IRS? But I think at the end of the day, Chairwoman Maloney has worked with so many people on this, particularly law enforcement, that I think this best addresses phony baloney companies where money is parked. Sometimes it's terrorist money, sometimes it's just illegal money that's being laundered through the particular little entity. A lot of times it's a little real estate, it's a condo or who knows what it might be, but a lot of times it's real estate. So I just appreciate the effort you've made and glad that you've brought it to this committee and are bringing it to the floor. With that, I yield back.
Thank you.
Thank you. Mr. Burgess? Thank you. Mr. Raskin?
No questions. I just want to thank Ms. Maloney and the ranking member for their leadership, and thanks for bringing this forward. Yield back.
Ms. Lesko?
Yeah, very quickly, Mr. Chairman. Mr. McHenry, you know, I'm concerned that there's no subpoena that's needed from law enforcement in order to gain this information. Is that, you know, are you concerned about that at all?
Yes, and that was one of the issues that was raised during the markup and the hearing about this. For the most recent collection of data that the Congress authorized, which was through the FISA court, and we have a governmental database that in order for governmental employees to look at, they must go before a court and get authorization. This database of small businesses has no such protections. That is one. And two, in addition to that, we've seen that there have been abuses of that FISA process of those governmental data, and that is just simply cell phone records, a question there. What we have before us is about the ownership structures of millions of small businesses, and they're the smallest of small businesses. And so while there's an intent to get bad actors and illicit finance, which we agree, the mechanism to protect those civil liberties was one that was a struggle. And we weren't able to come to consensus on that. That is one of my concerns with the bill, that quite frankly, we just couldn't come to terms on how to deal with this. Not because of lack of a goodwill from my colleague, but just because of the difficult nature of what we're dealing with.
And thank you. And one more question, Mr. McHenry. I'm going to be offering an amendment. It's actually a Denver-Riggleman amendment that basically says since we're creating this whole new database of personal information that there should be good cybersecurity regime. Would you support that?
Absolutely, and I supported it in committee. I think we need a discipline regime to ensure that we have separation of this data, and we're using the greatest encryption methods available in the marketplace to protect this data. If this database is to be created, we want to make sure it has the highest level of protection of any governmental database and the highest level of protection available in the private sector as well. Our colleague, Mr. Riggleman of Virginia, is an expert in that policy area, having made a career in the private sector and in our military on those very same issues of data procurement and also data protection.
Thank you. I yield back.
Ms. Scanlon?
Yeah, I was just trying to understand kind of what we're trying to get at with the bill. And it's to make sure we know who's really behind LLCs. So last week, there was a grand jury indictment that came down regarding Lev Parnas and Igor Fruman, the two gentlemen who were arrested at the airport. And as I understand it, they were using money that had been provided by a foreign national and laundering it through an LLC to then make campaign donations. Is this the kind of conduct that we're trying to target, to get behind those LLCs that are really just shells for nefarious purposes?
The gentlelady's question points to why so many law enforcement agencies, every single law enforcement agency in our country is asking for this information. They say it will save lives, that it will crack down on terrorism financing and other illicit financing of criminal activity. And there's a whole list of foreign governments buying entire buildings and not disclosing who they are. And it would allow them to better protect us. I, for one, want to help law enforcement protect our citizens. And I think it's a strong bill. I've worked on it for 10 years. And in response to the gentlelady's question, Representative Lukemeyer was very strong on privacy protections. All law enforcement agencies that access the information have to have an existing investigation going on. They can't just go fishing around in FinCEN and for no reason whatsoever. And FinCEN has to keep an audit trail of every request for beneficial ownership information so that they can detect anyone who is using the information inappropriately. But it's not only the laundering of money. Allegations come to me. I just report it to law enforcement. I don't know where it goes, but they'll come and say that this building is a cell, that there's a terrorist activity taking place there. I don't know. I just report it as required by law to law enforcement to follow up. But every other country knows who's buying their land and knows who's stashing money throughout their country. It seems to me like a sensible, common sense thing to do. Law enforcement, again, has asked for it, and they say it will make us safer and it will protect our citizens. Regretfully, since 9/11, there have been many attempts to harm us. Many have been thwarted before it gets started, but sometimes they have had 2 or 3 really violent attacks in New York where they stole buses and killed 50 people, smashing into them, where they blew up 2 suitcases of, it's a miracle more people weren't hurt. And then the question always is, where did it come from? Where did the money come from? Where did the training come from? And this is one of the things that they can look at. When we had the scandal in Panama, many people commented that there were no Americans that were disclosed stashing their money in Panama. And law enforcement says, why should they? It's easier to stash your money in America under plain sight, and it can be incorporated in an LLC, and there is no way you can crack it. And I've talked to people that have gone after an LLC. They've seen it go from one country to another, to another, to another, to another, to another, and they still can't figure out who owns it. CFIUS, one of their requirements is that, actually I filed a CFIUS complaint once, and they were disputing it, and I said, you've got to tell me who owns the LLC. And the true story, they went to every continent of America and back, and they couldn't find out who owned the LLC, and they denied the CFIUS request. I think that it's a very serious problem because a terrorist only has to be right once, and they can hurt a lot of people, as we've seen in America. So if law enforcement says they want it, and we've worked out a bipartisan compromise, the Republicans we worked with, they fought a very hard bargain and got a lot of changes and accountability that I'll say I believe really made the bill better. And if there's any area where we should have bipartisan support, it should be security, homeland security. We should work together in that area as we always have. And I want to thank my colleagues on both sides of the aisle for all of the efforts and bills that they passed to make this country safer, and to take care of the people who take care of us, most recently the Victims' Compensation Fund this year. Thank you very, very much.
Okay. Thank you, and I yield back.
Mr. Morelli?
I would just be remiss, Mr. Chair, if I did not congratulate and thank my friend and colleague from New York for her leadership on this important issue.
Thank you.
Shalala?
Yes, I couldn't be more pleased with this bill. I take it meets international standards now. But just as important, in South Florida, they'll be celebrating because it's one of the areas in this country where this issue is huge.
I must tell the gentlelady she's very correct. The Treasury, before coming out in support of this bill, did two pilot projects, one in New York and one in Florida. And they found out that the bill was needed because even when they announced we're doing this pilot project to see if people are hiding illicit money, still people had the suspicious activity reports. It was higher than any other place in the nation, even knowing that they were being tracked by the federal government in South Florida and New York. So thank you for raising that.
Thank you. Mr. Desaulniers? No further questions. I want to thank you both for being here, and you can feel free to go.
Thank you, Mr. Chairman.
I'd now like to call
Thank you, Mr. Chairman.
the gentleman from Ohio, Mr. Davidson, to testify. And while he's coming, I just want to welcome the former Rules Republican staff member, Kyle Matus, who's here, who used to be Pete Sessions' chief of staff, and he now works for the One Campaign, which is a global movement to end extreme poverty and preventable disease, and we appreciate their support of this bill. So thanks for being here. Mr. Davidson?
Thank you, Chairman. Thank you for entertaining my proposal, and I look forward to your questions. This is Davidson Amendment number 5. It is the first time presenting. And, my colleague, Chairwoman Maloney, highlighted that if there's one area that the Congress should have bipartisan support is security, but I think one of the things that we should get to first is liberty. We should all agree in defending civil liberties, and this amendment really is a civil liberties amendment. It says that if you want to search the data, then you need a warrant or a subpoena. And we required the same for the most critical data that is specifically targeted at foreigners, not Americans protected by our Constitution. We explicitly called that out in the Foreign Intelligence Surveillance Act reforms in the Patriot Act. All the further expansions and clarifications have said we treat Americans differently. But this database doesn't do this. This database requires no warrant or subpoena to search the data, or query it, as DOJ likes to say. And we know just recently that the FISA court found that as a matter of course, the FBI in 2017 had 3.1 million illegal searches of the FISA database in violation of the law, and the court called it out. So we do need to get to FISA reform. Clearly, the controls that we thought we had in place on that have proven inadequate, but there's still some controls. This bill doesn't even have controls. So, my colleague, Ms. Lesko, highlighted one in terms of how the data is structured, and we could all say, well, of course they'll get that right. Well, we could always hope they get it right, or we could take more steps to know that they get it right by requiring that they do. And we could hope that they don't abuse the authority to collect this data without a warrant, but we could take further steps to know that they don't. So the amendment emphasizes the strong privacy concerns that yet another database has. And I would say fundamentally, the law that's passed made it through committee and it made it to here, and we're going to have a vote on the floor, right? But it still thinks, well, I think the underlying bill is a bad solution to a real problem, because it presumes that every small business owner, that the best way to collect this data is literally 3 years of jail and $10,000 in fines if you don't fill out this piece of paper. And somehow the alleged, people that are violating this statutes for money laundering, tax evasion, or maybe violating sanctions, we're okay selling weapons to North Korea, for example, but if they have to file this piece of paper, they're out. The whole logic of this is flawed, and it targets Americans. The least we could do is make sure that the data we collect and is swept up intentionally in this case, unlike the swept up data in FISA, this is intentionally with criminal penalties jail and fines for not filling out a piece of paper with FinCEN every year, every time the data changes in terms of the beneficial owner, that we're not going to give the same safeguards. We give more safeguards to foreign data or swept up data than this data. So I urge the ability to at least vote on this on the floor, however you might vote on the end. Look forward to your questions.
Thank you very much. I have no questions. Anybody have any questions? Ms. Lesko?
Thank you. Just a comment. I support your amendment. I have similar concerns.
Thank you.
Mr. Perlmutter?
Yeah, just a statement. Mr. Davidson has been true in your direction on this. We worked together last year and the year before on this particular bill. His focus has always been on civil liberties, and appreciate your effort in that regard. I think finally for me, the fact that, the corporate shield, the LLC shield, people get that limited liability, and I think at some point they got to give something to get that. And that's where I've come down on this. But I just appreciate your dedication to your particular love and focus on civil liberties, and that's all I wanted to say.
Thank you, sir.
Any further questions?
Mr. Chairman?
Mr. Woodall?
I just want to ask Mr. Davidson if the committee had a chance to consider this amendment.
Committee did have a chance to consider the amendment, though it was pretty hastily offered. I will admit I spent the vast majority of my time trying to offer a different solution to the problem. And frankly, the whole piece, as both the chairwoman and the ranking member highlighted, FinCEN was somewhat less than helpful in working towards this. They proposed a customer due diligence rule that basically put banks under the obligation, and frankly, banks are already required to know their customers. It's just not as easy from the comfort of Washington, D.C. to query the database. So you might actually have to talk to the bank to get the data. So we tried to say, let's look at all the data that the federal government has collected and study how do we need to criminalize owning a business. And frankly, the premise is that, well, it's okay to privately own businesses and have private holdings, but you can't keep it private from everybody. You got to share it with us. So the Second Amendment will get after an alternative that would, instead of say ready, fire, aim, we would say ready, aim, fire, and study the problem a little better, and actually require FinCEN to be cooperative. And so this was offered really at the 11th hour, and so we really didn't have time to have dialogue in the committee about it.
And at this point, knowing the reputation that Mr. Perlmutter has placed upon you as being a worker in good faith with folks on both sides of the aisle trying to protect civil liberties, where we have come together in bipartisan ways to place limits on so many different agencies. As you talk with the chairwoman today, what is the challenge that we have? We all want to find the ne'er-do-wells here. We have a warrant process that allows us to investigate criminal activity. What has been the hang-up of getting partnership on this issue?
Well, twofold. As a matter of course, we know that the FBI now likes the idea to query the database at will, right? So 3.1 million searches isn't somebody wasn't paying attention. That's a way to operate. So they've structured the way that they operate their agencies to depend on querying this data. And that's in violation of current law for FISA. So they don't want to concede that they should have to jump through these hurdles in the future. They found it quite convenient just to search the databases. So the law enforcement agencies at the federal level have been reluctant to do it. And then frankly, because I was so strongly opposed, passionately I would say, to the underlying idea of criminalizing small business ownership, that some people doubted that this amendment was more than another effort to stall the bill. And, I'll concede I have not succeeded yet in stopping this bad idea from being implemented. But I hope that we'll reconsider, and frankly, bundling with the BSA, which is a good bill, while it accelerates the probability of the bill's passage, is a horrible idea.
I thank the gentleman. Thank you, Mr. Chairman.
And I think you have another, I'm sorry, I think you may have another amendment, right?
I do have another amendment, and the other amendment would say to not the overall macro solution, but to the requirement of criminalizing these business owners, would say before we do that, let's look, isn't there some other data that the government already has that they could make available to determine this? And if you look even further, requiring the secretaries of state at the time of registration, and the reality is the banks already have it. So the other piece is, as Ranking Member McHenry highlighted, the bill doesn't even get rid of the customer due diligence rule, which requires banks. So we're doubling down on it. We're requiring banks and businesses to file, and both have potential penalties. It seems that we would go one way or the other. And so here we're going to be certain we've got it, and if we don't get everything we want, we still have the ability to criminalize everything. And granted, we could go with selective enforcement, but that's what authoritarian regimes do, and I don't think most of our body supports that kind of a structure.
Thank you very much. Any additional questions? Mr. Promoter?
Under the bill, it's if false or fraudulent information or knowingly fail to fill out the report. So you go upon, you ask the state of Washington or the state of Colorado, we want to have the corporate shield, so that you can't get to us personally. I mean, I think at the end of the day for me, and this will be what the debate on the floor is all about, is that, okay, you want to use that shield, then you're going to have to give up something for it. And the false or fraudulent, provision, as well as knowingly fail to fill it out, really places the responsibility on the lawyers, in many ways. And that's been sort of the rub. The Bar Association's not particularly happy with this bill, but pretty much everybody else is. So we can have this debate when I carry the rule tomorrow, and we can talk about it.
Well, I look forward to that, but I would say in rebuttal that while the burden of proof should be on the people charging someone with a crime, I hope we're not ready to change that, although I've heard say of that recently from multi-corners of this body. But the only way to really adjudicate it is to win in court. So you have these smallest businesses. There's a reason the NFIB, the National Federation of Independent Businesses, strongly opposes. They only have 3 things they're working against right now. This is one of them. Not the overall BSA reforms, just this specific provision that the smallest, least sophisticated businesses would face 3 years in jail or $10,000 in fines. It's a heavy lever for the vast majority of businesses, overwhelmingly innocent. Surely we can be more focused. We're not even so focused as to require a warrant or a subpoena. So while the Second Amendment admittedly stalls the implementation of the underlying efforts Chairwoman Maloney has passionately pursued, the First Amendment at least says if we're going to do this, shouldn't we at least offer the same protections that we always offer in America, which is not for corporations, it's for owners. It's for the owners of the company, who are clearly citizens under every construction of the law.
Thank you. No further questions? Thank you very much.
Thank you all.
And now I'm going to yield to Mr. Burgess, who has an amendment.
Thank you, Mr. Chairman. I do have an amendment. And this amendment would require an annual report to Congress of the anonymized data on the number of beneficial owners per reporting corporation or LLC, the industry of each reporting corporation or LLC, and the location of the beneficial owners. So one of the greatest beneficiaries of the crisis on our southern border are the cartels and coyotes charging from $6,000 to $10,000 to smuggle people into this country, people who do not have legal documentation. We've all heard the journey through Central America and Mexico is dangerous. Many people, especially vulnerable populations, women and children, end up in the hands of traffickers despite having already paid this high fee for transit. Oftentimes, these people borrow money from their families to pay the fare for the coyote. They put their house or their farm up for collateral, and then after gaining entrance to this country and presumably going to work, they send home remittances, and those remittances go through legitimate financial transactions to retire these loans. And throughout this process, the coyotes and cartels are making money off of these vulnerable individuals. So providing data to Congress on how many beneficial owners are behind a company, the industry of the reporting companies, and the location of the beneficial owners could help us identify trends and patterns that could aid in the fight to combat money laundering and the financing of human smuggling. So we should not be facilitating coyotes to take advantage of desperate people. This amendment will provide some transparency to Congress on the networks behind this activity, and it's a starting point to identify these networks of illicit activity that are preying on people. For those reasons, I urge that the committee make this amendment in order.
Thank you very much. I have no questions. Anybody have any questions, Mr. Burgess? Hearing none, are there any other members who wish to testify in H.R. 2513? Seeing none, this closes the hearing on the Corporate Transparency Act. At this time, the chair will entertain a motion from the distinguished gentleman from Colorado, Mr. Perlmutter.
Motion for H.R. 2513. Mr. Chairman, I move the committee grant H.R. 2513, the Corporate Transparency Act of 2019, a structured rule. The rule provides 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Financial Services, now printed in the bill, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only those amendments printed in Part B of the Rules Committee report accompanying the resolution. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against amendments printed in Part B of the report. Finally, the rule provides one motion to recommit with or without instructions.
You heard the motion from the gentleman. We plan to make in order 5 amendments in total, 2 Democratic amendments, 3 Republican amendments. I must be slipping. But at this point, are there any amendments or comments, Mr. Cole?
Well, first of all, I was actually going to compliment you for 2 weeks in a row. We've actually had more Republican amendments than Democratic amendments. I want to thank you for that, Mr. Chairman. Appreciate that. We can make this even better, though, by accepting this. I'd like to have an amendment to the rule that would actually provide an open rule for H.R. 2513. Look, this is clearly the type of legislation that is not partisan, that we don't disagree on. We've had a lot of good ideas suggested here from both sides. I'd like to continue that process. I wouldn't expect anything unusual. So I just want to give more people more opportunities to come and participate in what I think has been a very good process in producing this legislation, including the action by this committee to make 5 amendments in order.
I appreciate it. And you heard the gentleman's amendment. Any comment or discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings. No. Mr. Hastings, no. Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. No. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall.
Aye.
Mr. Woodall, aye. Mr. Burgess.
Aye.
Mr. Burgess, aye. Mrs. Lesko. Aye. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman?
Mr. Woodall.
I have an amendment to the rule to make an order amendment number 4, offered by Mr. Gonzalez of Ohio to H.R. 2513. His amendment would require that FinCEN do a cost-benefit analysis on this legislation. We've heard from proponents about how valuable the legislation is. We've heard from opponents about what a burden it would be. This amendment simply asks FinCEN, which presumptively wants to participate in this, to give us that analysis so that moving forward we will know. I
appreciate the gentleman's amendment. Any comments or questions?
Mr. Chairman?
Mr. Burgess.
Yeah, cost-benefit analysis is such a basic part of any business decision. I find it astonishing that we would even consider doing something of this order of magnitude without providing the provision for a cost-benefit analysis.
Well, what I'm told, Gentleman Yield, is that FinCEN doesn't have the capability to do cost-benefit analysis. Other issues already covered in the underlying bill, and, yeah, that's what I'm talking about. FinCEN doesn't have the ability to do that.
That's startling in and of itself. I yield back.
All right. Any other comments? Hearing none, the vote is on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it? Okay. Further amendments? Hearing, okay.
I had one, but you
Go on.
made it in order.
Thank you, Mr. Chairman. I have an amendment to the rule to make an order amendment number 3 to H.R. 2513 offered by Mr. Riggleman from Virginia. This amendment requires FinCEN to institute a stringent cybersecurity regime to safeguard beneficial ownership information and requires any beneficial ownership information held by FinCEN to be encrypted. And I think that the amendment is self-explanatory. The government has not always done a great job safeguarding people's personal information. And so at the very least, if we're going to set this up, we should make sure that there's a cybersecurity regime to protect it.
Appreciate it. You heard the amendment from the gentlelady. Any comments or? Hearing none, the vote is now on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Okay. Are there any other amendments? Hearing none, then the vote will now be on the motion from the gentleman from Colorado, Mr. Perlmutter. All those in favor will say aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it, and the motion is agreed to. Clerk will call the roll.
Mr. Hastings. Aye. Mr. Hastings, aye. Mrs. Torres. Aye. Mrs. Torres, aye. Mr. Perlmutter. Mr. Perlmutter, aye. Mr. Raskin. Aye. Mr. Raskin, aye. Miss Scanlon. Miss Scanlon, aye. Mr. Morelli. Mr. Morelli, aye. Miss Shalala. Miss Shalala, aye. Mr. DeSaulnier. Mr. DeSaulnier, aye. Mr. Cole. No. Mr. Cole, no. Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mrs. Lesko. Mrs. Lesko, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk report the total.
9 yeas, 4 nays.
The motion is agreed to, and Mr. Perlmutter will carry it for the Democrats. And before we go, I'd just like to ask unanimous consent to insert in the record a letter sent to the committee from Mr. Raskin, asking that we postpone consideration of his legislation opposing the president's decision to hold the 2020 G7 summit at his Trump National Doral Golf Resort. And the president, thankfully, has changed his mind. So we will put that on hold for now. And then tomorrow, we will meet at 3 o'clock on the SHIELD Act. And anything else? Anyone? That, hearing no other comments or questions, the Rules Committee is now adjourned. Yeah.